We're now moving into a really important part of today's agenda, understanding the legal framework around health and safety responsibilities and the very real consequences that can arise when things go wrong. To guide us through this, we're joined by someone with extensive experience in this area. Matthew Harrington is a partner and executive board member at Clyde Co, one of the UK's leading law firms. He's advised and represented organisations facing serious regulatory and criminal investigations, including those related to the Corporate Manslaughter Act, gross negligence and health and safety breaches. Today, Matthew will be exploring the core legal duties nursery owners must be aware of and what happens when those duties are called into question. Please join me in welcoming to the stage Matthew Harrington.
Good morning, everybody. That is actually me. It was taken a few years ago, as some of you may have gathered. Although, unlike Chloe, I was even old there as well. So let me get rid of that as quickly as I possibly can. And I apologise immediately for the things I'm going to be talking about. I'm not here to scare you, far from it, but I think it's important to set the context, really, and to give you an idea as to the sort of challenges that you could potentially face should you be unfortunate enough to find yourself the subject of a criminal or criminal regulatory investigation, both in relation to your corporate entity and also should any of your members of staff or managers be subject to attention from the police, but also from what Chloe talked about. It starts with Lado, Ofsted, and it can soon develop very, very quickly into other things. And we'll try and finish on a more positive note as well, because there are things you can do, and I'm sure that many of you, if not all of you, are already doing to ensure that you manage risk appropriately in your business, and you can only do your best. Often, the police, more importantly for present purposes in terms of what I'm going to be talking about, the local authority, the Environmental Health Office or Trading Standards Office of the local authority, they come to these incidents with a big dollop of hindsight, when in actual fact the legal test is all about foresight. You're very, very fortunate to be with the Dot-to-Dot scheme. We act for a whole host of clients across the sector. They are the best. They absolutely get it. They work with their insurance partners and their professional services providers as well to provide quite an elite service, which is all about protecting you and ensuring that you have the support you need to circumnavigate your way through what can be really stressful, challenging, and an existential threat to you and your businesses as well. So although I'm going to hopefully try and finish on a more positive note, I'm afraid we are going to look at some gloomy headlines to get things started. Nursery firm fined £3,000 over a boy's death. That is a collector's item. That's from 2013. That kind of fine would never ever happen now because of sentencing guidelines that changed the sentencing framework for health and safety offences in 2016. And I've got a couple of slides devoted to that. But in terms of that particular offence, that was a health and safety case, pure and simple. A 10-year-old baby, he was being changed. He was on a 3-foot changing table. The nursery practitioner became distracted, went off to do something else. He fell off 3 feet, banged his head, serious injury. But the firm, the nursery business, was fined for health and safety offences under the Health and Safety at Work Act, £3,000. We'll see later that that sort of fine now would be tens of thousands of pounds, if not more, under the 2016 sentencing guidelines. That was a reasonably small firm in terms of the size of the business. The next one, 2022 case from Scotland. But this little boy, a 10-month-old baby, he choked on a piece of mango he was eating. Again, the nursery practitioners in question, one in particular, didn't quite have the attention where it should have been. And that lack of oversight created these conditions in which this little boy ate and tragically choked on a piece of mango. And he was, they were prosecuted for health and safety offences. They pleaded guilty. They were fined £800,000. That was a very, very big business. So I'm not suggesting, depending on the size of your particular businesses, that would necessarily be visited on you should you ever find yourself in a similar set of circumstances. But it does demonstrate the sort of fines that can be meted out for cases of that nature. They don't involve deliberate acts, bad practices, bad conduct of employees. They effectively are born, these two incidents were born from negligence, okay? And the nursery manager in that £800,000 case was also prosecuted individually under the Health and Safety at Work Act, and she, I think, received a suspended sentence. So that just also illustrates that for individuals, managers, employees, nursery owners, there is this potential for individual liability, which can result in custodial sentences. So those headlines dealt with businesses. These are three cases which deal with nursery workers. Nursery worker admits manslaughter after death of 14-month-old boy. That's a recent case. That guilty plea was entered, I think, in May of this year. Little boy, 14-month-old, as you can see, put down to sleep. He was put down in contravention of sleeping practice and guidance on his face. He was tightly swaddled. The blanket covered his head, and he was also pinned down by the manager at one stage, and he suffocated and died tragically. As part of the initial police investigation, 6 members of staff were arrested and were subject to individual investigation for potential criminal offences. If you fast forward then to earlier this year, the proceedings were issued. The nursery business was prosecuted, corporate manslaughter and health and safety offences. The nursery owner was prosecuted for offences under the Health and Safety at Work Act. The nursery practitioner was prosecuted and actually pleaded guilty to gross negligence manslaughter. She will be sentenced. She's not been sentenced. The nursery business and the owner have pleaded not guilty, and those proceedings will now take their way through the courts. But it's important to just emphasise that the subtext to all that, the nursery business is no longer a business. There were 2 settings. Both settings were closed. What Chloe talked about, Ofsted got involved. Of course they suspended registration in those circumstances. They extended the registration, then they cancelled the registration. The individual nursery owner, now bankrupt, lost her house, and she's now facing the stress and the challenge of this trial, both in relation to the business, which although it's no longer extant, it's no longer a going concern, it's still open to the prosecuting authorities and the courts to prosecute businesses if it's in the public interest. But this poor lady as well also faces the prospect of health and safety charges, a prosecution, a trial, all the stress that will involve, and potentially, if she's found guilty, a custodial sentence too. Polish worker 22, I mean, this was a really, really egregious case, quite extreme. You may have seen this. This was reported only last month in London. I mean, extraordinary that this young lady just literally assaulting little children in this, I think it was in Hounslow in London. And CCTV caught all this. One incident was spotted on CCTV. That triggered an audit of the previous 28 days, and all these other incidents which were charged then as offences came to light. Nursery worker guilty of killing baby girls, she found too demanding. That case is close to home. That is a case here in Manchester. Many of you will know of it. The nursery practitioner in question was a woman called Kate Ruffley. She was vastly experienced. She was prosecuted and went through a trial for gross negligence manslaughter here in Manchester over 5 weeks in April and May 2024. She was found guilty and she was sentenced to 14 years imprisonment. in conducting the review of CCTV, as the prosecuting and the investigating authorities always do now, they looked at the previous 28 days that were available, and they found other instances. Chloe mentioned this in one of her examples. They found other instances of another nursery worker, different children, 4 different children, subject to inappropriate acts, on the back of which she was prosecuted for offences and child cruelty offences. She pleaded guilty. She received a 3-year custodial sentence in September 2014. And of course, these are outliers. These are not normal. These are very much the exceptions to the rule, but they do heap pressure on you and your people as they try to do their best in what is an environment and a sector in which you have to manage multiple risks. It's extraordinary, the amount of risks that you have to manage. You have to manage the well-being of the children from the time they come in. No 2 children are ever the same. Some have ailments, some have medical conditions, some have food allergies and intolerance as well. That's a massive, massive challenge for you, particularly through a health and safety lens, because health and safety law is all about managing risk. It's how you, as practitioners, manage the risk in your setting in relation to children, essentially. So offences in relation to individuals which could have a bearing, and certainly did feature in some of the cases which I've just referred to, often where a nursery practitioner may be subject to an investigation and will come under scrutiny, usually by the police, as Chloe said, initially at least. It's the Children and Young Persons Act in 1993, and really what the police are looking at is there evidence of an assault, ill treatment, abandonment, exposing a child in a manner likely to cause unnecessary suffering. The case involving the 22 Polish nursery practitioner, it was very, very easy to invoke all of that in all 21 cases. And the evidence was there. It was incontrovertible because there was CCTV evidence. So it was an open and shut case. Gross negligence, manslaughter, unlawful act manslaughter. Obviously, these are cases that will only, so these are offences that could only be brought to bear in cases involving fatal incidents. So they're very, very much the exception to the rule. The case involving Kate Ruffley, she was charged actually for having committed unlawful act manslaughter, which it's not something she set out to do, so there was no intention, but through her conduct, her acts in particular, rather than omissions, she exposed the child in question, this 9-month baby girl, to a risk of harm. That harm materialised and that baby suffocated. She did plead not guilty, but as I've said, that was rejected by the jury and she was convicted. The other case involved the recent case I mentioned, where the plea was entered in May of this year. The nursery practitioner in question, when presented with the CCTV footage, decided to plead guilty at the first opportunity, and she pleaded guilty to the offence of gross negligence manslaughter. So there's got to be, in very simple terms, there's got to be a duty of care. She as an individual must owe a duty of care. That's going to happen. You as businesses, you owe those children, you care for a duty of care, that they're safe, to make sure they're safe, as do your employees. They owe the same duty. If it's breached, it's quite obvious when you can see, if you have the evidence, whether or not there's been a breach of that duty of care. The question then is whether it's a gross breach. Mere negligence, inadvertence, isn't enough. It's got to be really, really significant. So the kind of cases I've talked about where there's a defiant breach of sleeping policies and procedures, for example. You don't put the baby down on their back, you put them down on their front. You swaddle them tightly, cover their head. You don't do the checks you should do every 5 or 7 minutes, whatever it may be. All that, when weighed in the balance, can amount to a gross breach of that duty of care. And if it's gross, that will be sufficient for the police, in conjunction with the Crown Prosecution Service, to decide there is a case to answer here, and there will always be a public interest in cases involving the death of a child in a nursery setting. There will always be a public interest. So the Crown Prosecution, in conjunction with the police, will often say, we'll let the jury decide. We'll put the evidence before the court and we'll let the jury decide. This is a quote from Greater Manchester Police, from the lead detective following Kate Ruffley's conviction last year. And I'll read it for you, just in case you haven't got your binoculars at the back. This was a harrowing investigation which uncovered several unacceptable behaviours and practices at the nursery. It is clear to see that there was a culture of not challenging inappropriate behaviour, which ultimately placed several children who were under their care at risk of serious harm. Chloe talked about the culture earlier. She's absolutely right. So you might think you have a bad apple, a member of your staff who may have done something inappropriate, and that will start off as a police investigation, but through the process that Chloe talked about, Lado, Ofsted, all of a sudden the focus will then come away from the individual, because the police and the court system will deal with that, and there will be scrutiny on the corporate entity, you, the business. How are you managing risk? What's the culture like in your business? Are your people properly trained? Is there a whistleblowing policy? Do you keep your policies and procedures up to scratch? Are they reviewed? So it will, all these instances, all these cases we talked about, they start off police investigation, but it will evolve, and it can take many, many years. But your regulators, criminal regulatory enforcement entities, are your local authorities, the environmental health offices or the trading standards offices, and they will often be in the background, silent participants in those meetings, those allegations management meetings that Chloe talked about, involving Lado, involving Ofsted and the police, and they will be monitoring the position, and they will be gathering evidence very, very, very gently, very quietly, until such time as there's the time and space for them to focus their attention properly on the particular business, the particular setting. When these offences will often be what they'll be looking at. These are, or I should say, the duties. Whether these duties have actually been breached, which could give rise to offences and justify criminal prosecutions. The key offence is Section 3 of the Health and Safety at Work Act from 1974. And this applies to any health and safety setting. This could be steel, oil, gas, this could be anything. It's a general duty on every employer, in short you, to conduct its undertaking in such a way to ensure, so far as reasonably practicable, the persons not in his employment, so children, who may be affected, are not exposed to risk to their health and safety. So it's exposure to risk. It goes back to what I was saying about the management of risk. How do you manage risk? How do you safeguard effectively children who come into your care from the morning when they arrive to the time they're handed back to their parents? And this is a really interesting, just focus there on the words "so far as reasonably practicable." Because what that essentially means is that the onus is on you. If an incident happens, so say if a child in your care falls off a mat, a changing mat, and is injured, the onus is on you, and if that becomes the subject of an investigation by the local authority, the EHO, Trading Standards Department, what this section means is that incident having occurred, there's a reverse burden of proof. The onus is on you, as the employer, as the duty holder, to establish, to show, to prove that you did all that you reasonably could have done to avoid that risk in the first place. And that will involve an examination of ratios, deployment, training, competency, reviews, auditing process, all those things that you sometimes might think, why are we doing all this? Believe you me, the reason why you're doing it is a bit like house insurance. You pay those premiums, they go up every year, you hope to God you'll never ever need to make a claim on that insurance policy. But thank God if something happens, there's a fire or a flood, that's when you know that it's been worth making that investment. It's the same with this. You know, you need those policies, procedures, that constantly keeping things under review, it really is an investment worthwhile, because under this section, it's one part of the criminal law which is quite unlike any, and bear in mind we are dealing here with criminal law. It's the one part of the criminal law which differs from any other, because you, as the duty holder, effectively have to prove your innocence. I promise you I'll try to get a little bit more positive as things go on. Section 7 of the Health and Safety at Work Act, we don't see a lot of that, do we, Lindsay? We don't, but essentially duty upon employees to take reasonable care for health and safety of themselves and others who may be affected by their acts or omissions. In nursery settings, some of the cases that we've touched upon, or I've touched upon, the police they won't bother with this. They'll just look straight at the 1930 Act and whether there's been cruelty, assault, whatever it may be. But that is open to certainly the local authority. They will sometimes look at this as a potential offence. Has a member of staff actually, and it could be a manager, have they not actually discharged their duty, not so much in relation to themselves, but others who may be affected by their acts or omissions, in other words, children in this context, and that could justify an offence as well. This tends to be more relevant, though. It's Section 37 of the Health and Safety at Work Act, because this says that when an offence is committed with the consent or connivance of or attributable to the neglect of a director, manager, secretary or other similar officer, they, as individuals, can be guilty of offences that the business itself, so the business may be guilty of an offence under Section 3 of the Health and Safety at Work Act, and in those circumstances, if it's committed with consent, connivance or neglect of essentially a senior manager, can be an owner, but it could be the manager of the business, the manager of the setting as well, like the Scottish case. So the Scottish case with the £800,000 fine for the business, the manager was prosecuted under this, Section 37, and Section 3 of the Health and Safety at Work Act as well. This is not aimed at underlings, and there's a case from, I think, 1992, which says just that. This is aimed at people who really are the controlling, directing minds of the business. That's what it's targeted at. And it tends to be used for smaller businesses, for those who might have one nursery setting or two nurseries, maybe three. It doesn't tend to be used, and that's not just for this early years sector, that's for any sector. We tend to find it. So I had a case probably 4 years ago, it came to court. It was a gross negligence manslaughter case, and the scaffolding contractor who was prosecuted for gross negligence manslaughter, he was also prosecuted for health and safety offences under Section 37 of the Health and Safety at Work Act. And he was a one-man band. It was easy to say, well, he effectively was the business. So it tends to be used this in health and safety law and in health and safety law enforcement for 1, 2, maybe 3-man bands, or women bands if you would. So it's something that will be relevant to many of you potentially here in this room. And then we've got the Corporate Manslaughter and Homicide Act of 2007. This came in onto the statute book. I'm old enough to remember, as you can see from my earlier photo even, I'm old enough to remember this very well. And I remember the great publicity that came in. This was going to be a game changer. It hasn't been. It's been a real damn squib piece of legislation because it came into effect in 2008. And in 17 years, there's been about 40 prosecutions, maybe 30 convictions. Again, though, all really tending to be those small organisations that I talked about, and that's because of what the prosecution have to prove. So an organisation will be guilty of an offence under the Corporate Manslaughter Act if the way in which its activities are managed or organised causes a person's death and amounts to a gross breach of a relevant duty of care owed by the organisation to the deceased. So gross, that word gross again, so it's got to be really significant, really egregious. But also, that gross breach must be attributable to senior management. An organisation is guilty of an offence under this section only if the way in which its activities are managed or organised by its senior management is a substantial element in the breach of duty. Senior management in relation to an organisation means the persons who play significant roles in, one, the making of decisions about how the whole or a substantial part of its activities are managed or organised, or the actual managing or organising of the whole or a substantial part of those activities. So it does, again, this legislation, that this has tended to be used in cases involving smaller businesses. It could apply very easily, if you think about it, to your sector, to some of your businesses. That case I talked about from the Midlands, where the nursery practitioner pleaded guilty in May of this year to gross negligence manslaughter. The business, though defunct, ceased to trade 2 or 3 years ago, is still being prosecuted for corporate manslaughter. I've pretty much already dealt with this, but the investigating authorities, it's police for individual criminal acts, individual and corporate manslaughter, and the Crown Prosecution Service make decisions in relation to whether enforcement and the ultimate enforcement is a prosecution, whether there should be a prosecution. But many of you, it's this one that you've got to keep an eye on. These are the creeping assassins, if you like, the environmental health officers or trading standards officers employed by local authorities. They're often there in the background, Chloe, but they're there. We're always very conscious. Chloe and I work together. We overlap a lot on cases because we're always conscious that Chloe will be needed in the immediate aftermath, but we know that this lot are monitoring the position closely, and they have the capacity to visit a whole lot of pain on you and your organisations. Test for prosecution. Again, I've touched on certainly the public interest, but whether you're the Crown Prosecution Service or the local authority, EHO trading standards, when you've gathered all the evidence and you've got to make a decision on that ultimate enforcement that I talked about, which is prosecution, this is a two-stage test. The first limit is the evidential test, which is essentially, we have all this evidence. If we were to present it to a court, is it more likely than not going to secure a conviction? That will often be, so a legal advisor, a lawyer will usually make that recommendation, whether or not that test has been satisfied. And then the big one is the public interest test. So if the first test is a tick, if that's a yes, the public interest test is a prosecution in the public interest. That can be, certainly in the industrial sectors, that's so much a judgment of the individual HSE inspector. For you guys, you're dealing with children. It's, you know, it's sacrosanct. So the public interest is always easily satisfied, that test. You know, in any circumstances, really. And often what we find, we'll never be able to prove this, but we often believe that they always look at the public interest test first, which is not the way they should do it, and then go back and look at the evidence. And it's often this that is driving the investigation and often the decision to prosecute. And that's the challenge you face. That's why you really do need the cloak of protection very, very early on from dot to dot and all they can offer in order to put yourself in the best position to circumnavigate yourself through what can be an incredibly challenging period. And for this reason, because it is an existential threat, this is what Chloe was talking about. Your license, your registration suspended for 6 weeks, you've got your client base are your parents. You know, what are they going to do for the next 6 weeks? If it's extended then, if it's extended by another 6 weeks, it's 12 weeks, it's disastrous potentially. You know, it's all very well, and you're fighting your hardest to try and get that suspension overturned, released. It's very, very difficult, and all the time there might be a police investigation that's ongoing. The EHO, the creeping assassins that I described them, they're sort of getting mobilized. It's very, very difficult. I found this when I was preparing these slides in a health and safety periodical, which was on the nursery sector, the early learning sectors. And I'll, again, for those of you who've not got your binoculars, I'll do my best to read it. But small businesses in particular are vulnerable to health and safety failures. Between the direct and indirect financial costs and operational impacts, large businesses are usually better placed to weather the storm. they tend to have larger cash reserves and more resources to draw upon in times of crisis. However, small businesses suffer from greater cash flow issues and have less operational contingency should an accident happen or an incident happen. The HSE, local authority and police can close down a premises for many weeks, which is what Chloe was talking about, and months while they complete their investigation. Few businesses could survive the disruption and the resulting impact on customer service delivery. And as this sad story shows, even fewer can survive injuring their customers' children. So look, that's what you're contending with, and it's very, very difficult. And this is another. So in the first instance, you're battling, if you're the subject of an investigation, which all that might flow from it, you're battling with that. And then you might have this to worry about. If there's a good chance that it will result in a prosecution, or it actually does result in a prosecution, because these are the sentencing guidelines. This is I could bore you for hours on the sentencing guidelines, but I'm not hopefully going to do that today. And I'm hopefully not going to do it in relation to this subject. But these came into, Lindsay and I used to talk about them as the new sentencing guidelines, didn't we? But they're not new, because they've been in force since the 1st of February 2016. But these were an absolute game changer. Because the biggest single influence now on the outcome of any fine for health and safety offences is the size of a company, not the profitability, the size of a company by reference to, or it doesn't need to be a company, it could be a partnership, it could be a sole trader, by reference to its turnover, financial turnover. So, and they classify, there are 5 categories. You've got micro, a lot of nursery businesses fall into this category, turnover between 0 and 2 million, small, 2 to 10 million, medium 10 to 50, large 50 million plus, and then very large greatly exceeds the threshold for large organisations. But look at the fine range that's open for a micro company. Turnover of less than £2 million. Think about the margins that you're operating to. And the potential for the court to impose a fine, a 6-figure fine. And it's not just, the sentencing guidelines aren't just there for organisations. They've also got guidelines for individuals who may be guilty, not of the criminal offences of neglect and assault and all the things we talked about previously, but for health and safety offences. Financial penalty, percentage of weekly income, depending upon the seriousness of the offence and culpability of the offence. Custodial sentence for more serious offences, 26 weeks to 2 years. And then for limited companies with where the owners are directors, they can be disqualified for many, many years, I think 14 years maximum, under the 1986 Directors Disqualification Act. So this is the, so you get yourself through the investigation, you have Chloe and Dot to help you to survive, and then you might have to contend with this. And these are the area of scrutiny. I've talked about the legal duties, but this is what if we just think of this now in terms of pure health and safety, and the EHO, the creeping assassins, trading standards, so they're looking at risk, exposure to risk and the taking of reasonable care pertaining to the health and safety of children in the particular setting. A child doesn't need to be physically harmed or injured for a prosecution potentially to be brought. This is health and safety law. It's quite possible for the prosecuting authorities to bring a prosecution under the Health and Safety at Work Act where nobody's been injured. It's just sufficient for them to establish that you, as a duty holder, have exposed children or visitors to the premises, whoever it may be, you've exposed them to a risk of injury. And then, as I said, the onus goes on you to prove you did all you reasonably could have done to avoid that risk. It's very difficult to do. I've got a case starting in mid-September where we pleaded not guilty for a big organisation, and it's not in this sector, but there was a small gas release on their premises. And the HSE have taken a view, and they're prosecuting us. Nobody was injured. Evacuation procedures, there were all sorts of precautions and safeguards in place anyway. But the HSE have decided that, well, we don't care if nobody was injured, because a number of people could have been injured, and that's the key, that's the test. So over to you, organisation, to prove you did all you reasonably could have done to avoid that risk in the first place. That's quite difficult to do. We're going to give it a go, but we're under no illusion that's quite difficult to do. So they're looking at standards of care in the particular setting by reference to really early years, foundation, safeguarding welfare arrangements that you must meet for children under your care in those various age groups up to 5 years. Your policies and procedures, they're scrutinised, they'll be looked at inside out. Your CCTV will be pored over. You know, you might have the best policies in the world, but if you don't actually live by them, if they're not enacted, and if the CCTV footage, if you have it, actually shows that there wasn't compliance with what the policy says, that's problematic. Similarly, safe sleep. I've talked about a couple of cases involving egregious departures from safe sleep practices, not only from NHS guidance and early years foundation guidance, but also in the organisations written procedures who those nursery practitioners were trained in. Chloe, sorry, Chloe, I feel as though I should. Did you write any of this for me anyway? But Chloe talked about whistleblowing. It's really, really interesting now that if in terms of deliberate acts or omissions, it's very often easy to identify the perpetrator or the person who has been guilty of an omission. A negligent omission which has given rise to a risk of injury or worse, an injury to a child. But it's other workers as well who are potentially in the frame if they don't whistleblow. We have another case where a child was, for want of a better description, force-fed by a very senior nursery practitioner. And 2 members of staff in the room at the time did nothing. They were arrested along with, when this came to light, they were also arrested, and they are under investigation as we speak. So whistleblowing is a really hot topic in this area. As a result of which, the investigating authorities, EHO, trading standards, they're going to be looking at the training and competency of staff. Were they competent to do their jobs? Were they monitored? Management and supervision, auditing. You know, you can't take people on trust anymore. There's got to be more than that. You know, were you testing the competency and training of staff? And risk assessments, again, Chloe talked about risk assessments. It was a big part of one of your slides in relation to activities, equipment. So all this stuff, you know, ratios, sleeping practices, food hygiene, and the like, all need to be covered by risk assessments, but activities, equipment, apparatus as well. These are the areas. So when it pivots from the individual, the police move away, and then local authority comes in, and they're looking at those broader cultural issues, the management and the organisation, the leadership. These are the issues they're looking at. These are the areas they're looking at. So I'm sorry about all that. I mean, that sounded terribly gloomy, but there are things you can do to help yourselves. There are things I'm sure you're doing. I mean, we're not here to patronise you. Look, but for the last 30 years, maybe you probably thought looking at my photo it was longer than that, but it is only about 30 years. But so many clients have said to me at the end of a case, it's been lovely meeting you, Matthew. I hope I never, ever meet you again. And I never, ever take offence, because I'm obviously, so the fact that I get involved means that they're going through a terribly stressful period where they have all sorts of challenges to battle and to overcome. And we always say glibly, perhaps, that prevention is the best form of cure, but it really is. If you can avoid this, then fantastic. I mean, but if you're not lucky enough to, or if you're unlucky enough that something might happen which brings a level of scrutiny upon you, then you will undoubtedly help yourself if your documentation is there. And I'm talking about policies and procedures, and they need to be up to date to reflect changes in legislation, guidance, management changes of staff. The optics really are important. I was in an interview under caution, so as a legal advisor, I hasten to add, rather than as a suspect, in April, in an awful case involving a nursery setting, in which one of the owners of the business was being investigated in an individual capacity as well as the business itself. And he was shown a number of policies and procedures, health and safety policies and procedures, and asked, well, it says that the head of health and safety here is so-and-so. That person had left 3 years ago. And that was a good business, in fairness. I mean, I think that the police, because it's a manslaughter investigation at this stage, I thought the police were being heavy-handed. I thought their approach left a lot to be desired. But optically, that just didn't look good. This was a well-run business, but the fact that their policies and procedures hadn't been updated when Joe Bloggs had left 3 years ago, all of a sudden it took on a resonance and importance that one could never have imagined it would do in that pressure cooker of a police interview under caution. CCTV, increasingly important. Hands up, those of you who do have CCTV in your settings. I love this lady, she's writing everything down. But, sorry, are you a CCTV?
No.
No?
It seems to me it can incriminate you, so...
Whoa, hang on. I'm going to ask the question another way. Hands up those of you who don't have CCTV. Now, if you ladies would like to... Oh, keep your hands up. So if you just look around, there's not many of you. I mean, you really are in a very small minority. You're absolutely right. It can be problematic in terms of, because it's brilliant evidence. It's the best evidence, particularly where the audio's working as well. But it also can be hugely helpful. So 4 weeks ago, not one of your cases, Jackie, you'd be pleased to hear. It was your old friend Peter Webb, though. He phoned me up. He said, look, we've got a bit of a problem on this case in another jurisdiction, but we'd like you to get involved in it. And it involved allegations, very serious allegations involving 2 of the nursery practitioners of sexual nature, involving small children, 3, 4-year-olds. And it became quite clear very quickly after first, maybe second meeting, reviewing documentation, speaking to people, that there was something not right here about the allegations and that there wasn't really an awful lot of. But as you know, Chloe, sorry to reference you again, these allegations, once these are made, they're very serious. And you know, the regulatory authorities and the police, they can't just, they've got to open a file, they've got to open an investigation, they've got to do the bare minimum at least. No CCTV. We've narrowed it down that this could only have happened in a certain window on a particular day. And there's no CCTV. So we don't think anything of this nature happened, but if there had been CCTV, we could have excluded it very, very quickly and we could have all moved on. As it is, the 2 nursery workers have been arrested, released under investigation. That was 6 weeks ago, and the investigation, we're trying to bring pressure on the police to sort of move this on, but they're saying, well, we have to, because of the public interest and the scrutiny that we're under in Ofsted, and we've got to take this, in stages and follow a due process. But I agree with you. I mean, it is a bit of a double-edged sword. My own view, better to have it than not. And I think it can be used as a risk management tool as well. What's become clear in the investigations that we've been involved in is that the allegations are forming that, well, you've got this CCTV footage, but you're not doing anything with it. Why don't you review it periodically? Now, obviously, you're all very time hungry. It's you're juggling all these things operationally to do what you're contracted to do with your customers, the parents. So it's very, very difficult to fit all this in, but it would be helpful if somewhere in your time management, you can maybe once every couple of weeks set aside some time to randomly look, maybe set aside an hour or two to randomly just look at CCTV footage from different parts of the setting. And if there's anything, if there's anything there that piques your interest or you think needs a conversation, have the conversation. A low-level investigation, if it needs more of a detailed investigation, then obviously conduct more. But low-level investigation and document it. Document it, because then should anything terrible happen which triggers an investigation by police or local authority, you can actually say to them, well, this is what we're doing as part of our supervision, monitoring and auditing practices. It really does help. It makes a big difference. We lawyers love documentation because judges and juries like documentation. But you're right, CCTV will be used in evidence, and we're seeing that increasingly. But as I said, it can be used to your advantage. And the cases that I talked about in opening, they really are the exception to the rule. You know your people, the people who work for you, often know your parents very, very well. But the people who should know your nursery practitioners best are you. But sometimes you just might not necessarily know them as well as you think you know them, which is why all these things are so important. Because the Kate Ruffley case, she worked for that business for 17 years. And her record was spotless. And it came as a complete shock to everybody, not least the owners of that business, when having had all the awful stress of this happening to this little girl in their setting on that day, it suddenly came to pass. They came to realize that actually there's something sinister has happened here. And everything at that point stopped and had been on stop ever since. So that incident involving Kate Ruffley ruined, well, it ended one life, it ruined several more. The family, they were on Good Morning Britain yesterday, they're campaigning. Obviously, the nursery, Kate Ruffley, I mean, it ruined so many lives. And they did have CCTV, the nursery, but it never dawned on them they might be using this CCTV as a risk management tool. So just have a think about that. Okay, thank you.